Welcome to Episode 10, Retroactive Amendment of Approved TDY Authorizations. In this episode, you will learn the standards for retroactive amendment of approved temporary duty authorizations, including the associated governing rules and the 3 legal standards for retroactive amendments. By the end of this episode, you will learn the primary purpose of the rules regarding retroactive amendments, the general meaning of the term retroactive amendments, the governing rules regarding retroactive amendments, the roots of most retroactive amendments, the best ways to prevent improper retroactive amendments, the 3 specific circumstances when retroactive amendments are allowed. Some examples of when retroactive amendments are expressly allowed.
The following symbols draw your attention to a particular point or topic. The red circle and exclamation point denotes a very important point. The yellow caution triangle denotes a safety note warning that failure to heed the point will likely cause significant issues. The blue exclamation point and banner denotes a best practice. And the blue binoculars denote a case study used to further explain or provide an example. There is great authority vested in supervisors to determine when it is necessary for an employee to travel to perform the government's business. Once exercised, considerable authority is vested in the employee to incur expenses. The rules regarding retroactive amendments are based in preserving those rights vested in employees once the vestment is made. At the same time, the vesting of these rights does not establish carte blanche or invitation to an employee to discard prudence or responsibility. Nor should it be seen as the government broadly accepting liability for an employee's actions. The following original ruling by the Comptroller General of the United States establishes the overarching standard regarding retroactive amendments. See Dr. Sigmund Fritz, 55 Comptroller General 1241, 1242, 1976. Once travel is authorized, the traveling employee's right to reimbursement of travel costs vests as the travel is performed, and valid travel orders cannot be revoked or modified retroactively, after the travel is completed, to decrease rights that have already become fixed. The rule regarding retroactive modification or amendment of travel orders is that under orders entitling an officer or employee to travel allowances, a legal right to such allowances vests in the traveler at and when the travel is performed. It may not be divested or modified retroactively so as to increase or decrease the right which has accrued. In other words, such a right becomes fixed under the applicable statutes, regulations, and orders for travel already performed. A retroactive amendment is when an approved TDY authorization is amended after the start of a trip to increase or decrease the amount payable to the employee. An approved TDY authorization serves to fix the expense types and amounts an employee may incur and provides written notice to the employee of this. The rule is simple. With few exceptions, an approved TDY authorization cannot be retroactively amended once travel has started. Retroactive amendment of an approved TDY authorization without there being a basis for doing so is falsification under 18 U.S. Code Section 1001. 18 U.S. Code Section 1001, statements or entries generally. A. Except as otherwise provided in this section, whoever, in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States, knowingly and willfully 1. Falsifies, conceals, or covers up by any trick, scheme, or device a material fact. 2. Makes any materially false, fictitious, or fraudulent statement or representation, or 3. Makes or uses any false writing or document knowing the same to contain any materially false, fictitious, or fraudulent statement or entry. Shall be fined under this title, imprisoned not more than 5 years or, if the offense involves international or domestic terrorism, as defined in Section 2331, imprisoned not more than 8 years, or both. If the matter relates to an offense under Chapter 109A, 109B, 110, or 117, or Section 1591, then the term of imprisonment imposed under this section shall be not more than 8 years. The rule prohibiting retroactive amendments applies only to the expense types and amounts payable to the employee. The rule does not apply to expense types and amounts not payable to employees, such as TMC fees and ETS system fees. The rule is also not applicable when the designated approving official is performing their FTR prescribed duties of allowing or disallowing expenses. Additionally, there are 3 specific situations in which retroactive amendments are lawfully permitted. We will discuss these in more detail later. 1. To correct an obvious administrative error on the face of the document, or 2. To correct application of law, regulations or agency instruction, or 3. To correct definite agency intent. The most common rationalization for improper retroactive amendments, falsifications, is because the employee failed to fully consider the travel expenses they would need. They then incur expenses improperly and expect to be made whole. Rationalization is not justification, it does not establish a legal basis to make retroactive amendment. Travel program administrators, designated approving officials, and even certifying officers must avoid compounding errors by allowing retroactive amendments to occur when the amendments do not comply with the rules. Sometimes an employee acts based on bad information. This might be from their own understanding of information, from bad policy, from a management official's erroneous decision, or for some other reason. The Civilian Board of Contract Appeals has succinctly said in numerous rulings in this regard, an agency may not pay monies in violation of statute and regulation, even though the travel authorization purported to create the entitlement and an employee relied upon the authorization to his detriment. Training and correct application of the rules when administering travel are the best ways to prevent improper retroactive amendments. Foremost, the employee bears the responsibility to be prudent in this regard, to take care to plan the travel. There is a fundamental, overarching principle that a federal civilian employee traveling on official business must exercise the same care in incurring expenses that a prudent person would exercise if traveling on personal business. See Jack L. Hovick, CBCA 655 Trav, 07-2 BCA. As noted earlier, there are three lawful exceptions when it is permissible to retroactively amend an approved TDY authorization. 1. To correct an obvious administrative error on the face of the document, or 2. To correct application of law, regulations, or agency instruction, or 3. To correct definite agency intent. We will examine each one more closely and provide illustrative examples. The examples reflect common examples and are not all-inclusive. As a rule of thumb, it should be readily clear when a lawful exception is applicable. If it requires overthinking, stretching of the bounds of credulity, rationalization, extensive explanation, or justification by extension, then the exception is likely not applicable. An employee traveled to Denver, Colorado to perform temporary duty. However, the location was mistakenly set to Denver, North Carolina on their approved TDY authorization. As a result, the wrong per diem was calculated for the employee. The approved travel authorization may be amended retroactively to correct the obvious administrative error and ensure that the employee is paid the correct amount. Forgetting to plan the expenses and amounts needed is not an obvious administrative error. Remember, a prudent traveler fully plans their trip and determines the expense types and amounts needed, and they request this on the TDY authorization request. An employee's TDY authorization has the per diem rate for the TDY location approved at 400%. However, the federal travel regulation limits the rate under the actual expense per diem methodology to 300%. This would be a misapplication of law or regulation that would need to be corrected. Note that an agency instruction means an agency policy. Supervisory discretion to initially authorize an expense type or amount does not establish authority to change the amount payable later after the TDY authorization was approved. If an authorization is amended to extend a trip, then this is new authority pertaining to the portion of the trip going forward, not for the portion of the trip that has already occurred. In certain circumstances, law or the FTR allows for retroactive amendment consistent with correcting the application of laws and regulations. FTR Section 301-11.302 allows for after-the-fact approval of actual expenses. So if an employee arrives at a TDY authorization and finds the economic conditions require actual expense per diem authority, the designated approving official may authorize the retroactive amendment of approved travel authorization to allow actual expenses greater than the lodgings plus rate, up to 300%. The intent of the Americans with Disabilities Act is to accommodate employees with health-based needs in performing essential elements of jobs. So, if an employee has a health-based need, such as a broken leg, and must incur an expense allowed by the FTR, such as renting a mobility scooter, then the TDY authorization may be retroactively amended for this purpose. This exception requires careful study because it is often applied incorrectly. First, we'll clarify the word definite. It means clearly defined or determined, not vague or general, fixed, precise, exact. Further, there is a very high standard to meet to establish definite agency intent. The standard requires documentary evidence dated prior to the start of the trip, such as email, a memorandum, a cable, etc. What does not meet the standard? After-the-fact testimonials, findings of investigations, administrative inquiries or audits, justification memos, management determinations or decisions, rationalizations, agreements, sympathy, fairness, etc. An employee and their supervisor discuss by email plans for an upcoming temporary duty assignment. The employee and supervisor clearly agree a rental car is necessary to meet the objective of the trip. The supervisor clearly and without ambiguity states in the email, "Yes, a rental car is necessary and I'll authorize one." The employee travels and rents a car. Upon returning to the official station, the employee finds the rental car was not listed on the approved TDY authorization. It is within the agency's discretion to direct the method of transportation, so the dated email would suffice to establish definite agency intent. Note that the supervisor's agreement must be unambiguous, definite. It is necessary to illustrate a common misunderstanding regarding definite agency intent. An employee travels and rents a car on their own volition. In filing the travel expense voucher claim, the employee lists a rental car. The employee submits a justification memo. The claim fails processing, so it is returned, the expense is added, and the claim is reapproved. The designated approving official then approves the expense on the claim. The approving official justifies this decision because it is not intended for the employee to pay out of pocket for the government's business. It is not fair to the employee. The system allowed the authorization to be amended, they wrote a memo to cover their decision, etc. However, the expense cannot be allowed. Regardless of the rationale or justification, the situation does not meet the standard for retroactive amendment. The liability is the employee's. Making the retroactive amendment in this example is falsification. See 18 U.S. Code Section 10011A, B, and C. In certain specific circumstances, the FTR allows for retroactive amendment consistent with correcting definite agency intent. Section 301-10.123 allows an agency to approve other than coach class accommodations to meet a health need. The same goes for train fare. Definite agency intent is also established when an employee has an approved reasonable accommodation agreement in place. Which of the following is a legitimate reason to retroactively amend an approved temporary duty authorization? A. The employee has an unplanned transportation expense. B. The designated approving official writes a justification after the fact. C. There was an obvious error on the face of the authorization. D. The employee incurred an expense and it is only fair that they be reimbursed. Pause the video, consider your response, and resume to learn the answer. The correct answer is C. There was an obvious error on the face of the authorization. Choose all that apply. Retroactively amending an approved TDY authorization without a basis in law is A. Falsification, which is a felony. B. Justifiable if a memorandum is written to explain the circumstances. C. Not allowed. D. Done all the time, so it is no big deal. Pause the video, consider your response, and resume to learn the answer. The correct answers are A and C. Falsification, which is a felony. Not allowed. Choose all that apply, which are not bases for retroactively amending an approved TDY authorization. A. To settle an employee's grievance. B. Results of a management inquiry or investigation. C. A justification memorandum. D. Documentary evidence of definite intent dated prior to the TDY. E. Fairness to the employee/claimant. F. The supervisor erred in allowing an expense type contrary to law or regulation. G. Personal hardship. Pause the video, consider your response, and resume to learn the answer. The correct answers are A, B, C, E, and G. To settle an employee's grievance. Results of a management inquiry or investigation. A justification memorandum. Fairness to the employee/claimant. Personal hardship. Which exception would apply if an employee's TDY authorization needed to be retroactively amended to allow their approved reasonable accommodation? A. To settle an employee's grievance. B. To correct an error in the application of law or regulation. C. An obvious administrative error. D. Definite agency intent. Pause the video, consider your response, and resume to learn the answer. The correct answer is D. Definite agency intent. A designated approving official approved a TDY authorization for an employee to be reimbursed lodging in the area of the official station. Which basis is applicable for retroactively amending the authorization to not pay the employee? A. To correct an error in the application of law or regulation. B. To correct an obvious administrative error. C. To correct definite agency intent. D. None of these. The employee should be paid, because it was the supervisor's error.
Pause the video, consider your response,
and resume to learn the answer. The correct answer is A. To correct an error in the application of law or regulation. What is the primary purpose of the general rule regarding the limits to retroactive amendments of approved TDY authorizations? A. To correct an error in the application of law or regulation. B. To correct an obvious administrative error. C. To correct definite agency intent. D. To protect the rights vested in the employee to incur travel expenses.
Pause the video, consider your response,
and resume to learn the answer. The correct answer is D. To protect the rights vested in the employee to incur travel expenses. What are the best ways to prevent improper retroactive amendments? A. Train supervisors to not make errors in approving TDY authorizations and establish policies for when retroactive amendments may be allowed. B. Train employees on their responsibilities and how to plan temporary duty and apply the rules correctly when administering travel. C. Write policies that specify when retroactive amendments may be performed. D. Reserve retroactive amendments for those circumstances when it is necessary to make an employee whole.
Pause the video, consider your response,
and resume to learn the answer. The correct answer is B. Train employees on their responsibilities and how to plan temporary duty and apply the rules correctly when administering travel. If a certifying officer approves a travel expense voucher claim that facilitates an improper retroactive amendment, can they be held personally financially liable for the resulting improper payment? A. Yes. B. No.
Pause the video, consider your response,
and resume to learn the answer. The correct answer is A. Yes.
Congratulations! You have completed this episode. Thank you for participating. The next episode in this series is episode 11. Basic Concepts of Travel System Administration.